The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont, PA. We're with you every Saturday afternoon from 2 until 4 o'clock on our flagship station, News Talk 610, 100.3 WIOD, and, of course, News Radio 970 WFLA. The number's the same wherever you are. If you're listening to the show, you can call in and talk to the experts. We have attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. That number is 866-610-NEWS, 866-610-6397. AT&T Wireless customers, star 610.
And good afternoon. I'm Shay DuPont here with Michelle Hanash, who is a bankruptcy attorney in our office at Morris DuPont. Today, I wanted to kind of do one of those back to basics that I like to do about every 3 months and talk to you about some of the basic issues that we see over and over again at the law firm of Morris DuPont. And one of those is how it works when you go into default on your mortgage. What actually happens? And what are some of these different words actually mean that the lender might use, sometimes actually to scare you or threaten you? Because we see a lot of people coming through our door that believe that they are in foreclosure because they have defaulted on a mortgage. So let's step back a minute today and go through that process and sort of walk you through it from the beginning. When you've missed a mortgage payment, what is your lender going to do? Well, let's say that you missed your November 2013 mortgage payment, and today is November 16th. That means that you are one day typically outside of the grace period. If your mortgage payment is due on November 1st, then typically you have a grace period to make that payment until the 15th of the month. If you have not made that payment by the 16th, you are out of the grace period and considered to be past due on your payment. You should start receiving telephone calls from your borrower, from your lender, wherein they are asking you when you intend to make this payment and how, and gee, could they be really good to you and help you to facilitate that payment while they're on the phone with you. If you cannot afford to make that payment, they will try to help you schedule a time when you can make that payment. But let's say you have no intention of making that payment, or you aren't able to make that payment because you just don't have the money available. And time goes on, and December 1st rolls around, and you still haven't made a payment. And December 15th rolls around, and you still haven't made a payment. And it gets to December 16th. You are now 1 month past due, and you are outside of the grace period on the second month. So your lender would consider you to be 46 days past due. This starts to become a problem. The lender could put you on what's called an auto dialer. An auto dialer is a computer program wherein that auto dialer should be making sure that your telephone number is called at least twice a day. Normally once in the morning hours and once in the afternoon hours. If you pick up that phone, then the auto dialer will route that call so that a live human being working for the lender in a call center will be on the other end of the line to speak to you, again, to ask you when you could make a payment. And in that phone call, they might actually tell you that because you are now 46 days past due, your account is being referred for foreclosure, and that you are now in foreclosure. Well, these are lies. You are not in foreclosure when you are 46 days past due. You're not in foreclosure when you are 45 months past due, unless your lender has actually directed their legal counsel to file a lawsuit against you and the property in the county in which you live. That requires your lender to go to their legal counsel, show them evidence that you have not made the payments, and their legal counsel is now required in the state of Florida to actually do some amount of checking with the lender that the lender has done the appropriate investigation to make sure that the lender is correct. Number one, that you are past due. And number two, that they are the actual lender that has the right to file a foreclosure action against you and the property. And named in that foreclosure action would be anyone that has a financial interest in that property. That would include your spouse. That would include your homeowners association. That would include any lien holder on the property. If there's a mechanic's lien on it, if the IRS has a lien on the property. Michelle, you see a lot of credit card liens on properties.
Judgment liens, right? Those are other kinds of liens.
Right. So any of those lien holders on a property would also be named as a defendant, because anyone that has a financial interest in your property, which would include a tenant, because they have a lease, would be named as a defendant because their financial interest in the property would also be being foreclosed on in that foreclosure case. So as you can see, the clock actually moves rather slowly. It typically takes a lender approximately 6 months to file an actual foreclosure case against a borrower who has defaulted on a mortgage. So if you have defaulted and not made your November payment, well, April, I'm counting, the end of April. So maybe in May, we'd start to see a foreclosure action being filed against you. How would you know that the lender filed a foreclosure action against you? It's very simple. Knock, knock, knock. That's right. A process server is going to knock on your door, and they are going to serve you with the actual physical complaint. You do not have to sign for that package. You simply have to have someone 16 or older who is a resident of the property, not your once-a-week housekeeper, but someone 16 and older that lives on the property, not your guest who is staying there for a week. They have to accept service of the paperwork, and then the process has been completed. You have now been properly served, even if it was your 17-year-old son who was there at the time. So that is how the foreclosure process works. That is what happens once you have been served with a foreclosure action. Michelle, maybe you want to go through what happens when they are served actually with a litigation regarding their credit card.
Right. So there's a similar process that will occur in regards to being served with a lawsuit regarding your credit cards. Once again, you're not going to be served with a lawsuit the day you miss your first credit card payment. So you're not going to be involved in litigation normally right away. And it's interesting to point out that the vast majority of individuals who do actually default on their credit cards, unlike perhaps defaulting on a mortgage, don't end up in litigation, because I wouldn't even be able to quantify the number of people currently who have defaulted on credit cards. They're certainly not all in the legal system.
No.
So once you default on your credit card payment, you as well will start being on the auto dialer and will be called, I think it's more than twice a day. I think they might be calling minimum, from sun up to sundown is what my clients typically tell me. And they will reach out to you. You'll start receiving letters in the mail, typically trying to get you to make payment or letting you know if someone else has purchased your loan.
Well, Michelle, let's break there, and we'll come back after we have to take a break and hear some great commercials from some of our sponsors, and we'll go forward with what happens once the litigation is initiated.
You're listening to the Home Mortgage Law Show, 1-800-974-2712. That toll-free number gets you a free consultation at the law firm of Morris DuPont. If you can hear the show, there's an office near you. Just pick up the phone and call toll-free 800-974-2712. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont, PA. 866-610-NEWS. That's the toll-free number here in the studio to talk to the experts, attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. 866-610-6397. AT&T Wireless customer, star 610. Now, I hear that both of you were very, very busy.
Well, it's been a busy week, I will say that. But of course, we had Veterans Day. And of course, my department, Michelle, worked on Veterans Day, but I noticed your department seemingly took the day off.
Well, not just my department, but my department and the foreclosure department did have a little bonding day
Yeah.
where we went and had a beach/spa day.
Really?
Yes.
How very nice.
It was.
Well, that's because you guys deal with the courts all day long.
Right.
And of course, my department, the loss mitigation department, deals with departments within the lender where they don't take Veterans Day off. So, of course, well, look, let me put it this way. Let me preface it by saying that, of course, we all take Veterans Day off, but my department had voted, I think the whole firm had voted several months ago that we would switch Veterans Day and we would instead agree to take off the day after Thanksgiving. So we have a nice long weekend for everyone.
Right.
But you guys seem to have just kind of
We
disregarded.
took them all. See, my strategy is whenever one of these votes come up, I always vote for the first day off because I figure later on no one's going to want to come back after Thanksgiving.
But you know what? She takes the day off and apparently took the laptop and the phone with her.
Yes,
Uh-oh.
I was definitely working part of that day. You know, I was ready to relax, but I had to prep for court the next day and call the trustee's office for hearings. So hopefully it didn't sound too windy in the background when I was making my calls.
Seagulls fly.
Yeah, pretty much.
Very nice. Well, we actually took, the loss mitigation department actually took a team day yesterday, and we went to a place called Boomers in Hollywood, Florida, which I had never heard of, but I know every city has one of their Boomers where you have laser tag and wall climbing and go-kart races and oh my God, we did every kind of game that they had there. It was a very, very fun day.
Lawyers do have fun.
Well, you know, everybody in my department works super hard. Everyone in the
Right.
whole firm works really,
Right.
really hard. And what we do is we hire from within. So as we grow, we are trying to bring people up and train them into new positions. So in the loss mitigation department, we actually, in the last 4 or 5 months, have 3 new employees. Well, they're not really new. They're just our receptionist is now in the loss mitigation department. Our old appointment scheduler is now in the loss mitigation department. So we're bringing up these women through the different departments. And so we wanted to kind of bond with them as well and, you know, keep the team, you know, kind of spirit going. So we wanted to have a fun day off and kind of re-energize and, you know, get ready for the next 3 months, which usually is very, very busy towards the end of the year as these lenders want to sort of close out some of these files, these problem files they have. So what happens is we could be fighting on some of these tough files, and then suddenly towards the end of the year, they start really speeding them up and requesting documents, and they are trying to get them off their books. So we are moving at breakneck speed. So we kind of wanted to get a little lull going before we know what's going to be happening November, December.
It's
and
such
then
a stressful
January.
time, too, for homeowners that are going through a situation like a foreclosure or bankruptcy,
Right.
especially the holidays.
It is. And I also hope it's a time where people are thinking of that New Year's resolution and saying, I do not want to spend another year in this property without getting some resolution. I have got to hopefully contact the law firm of Morris DuPont. I've got to contact Morris DuPont, and I have got to get this process started so that I can, you know, start the new year fresh and be able to know that I am moving forward with a resolution to the issues that I'm having with the mortgage, with living paycheck to paycheck, with continuing to put some payments on credit cards. You know, we just came out with the new HAMP report. Michelle, I know we want to get back to you, but I think it's an important time to sort of segue to the latest, what they call the Obama scorecard regarding the Making Home Affordable program. It was just recently released, and it gives us a scorecard as to how the Making Home Affordable program, which is the biggest loss mitigation program out there for homeowners, how it's doing, how many homeowners it's helping. And I thought the scorecard looked really good this year, Michelle.
I did too. I don't want to jump right to that principal reduction. I'll let you get there, but that's what jumped out at me.
Exactly. Well, this is as of September, more than 1.2 million homeowners have received a permanent modification through the Home Affordable Modification Program. That's HAMP, the Home Affordable Modification Program. We talk about HAMP all the time. That's the largest, the biggest loan modification program out there. It is sponsored by the Department of Treasury. And those who were granted permanent relief through HAMP are saving on average $547 on their mortgage payments each month. That's almost a 40% savings from their previous payment on average. Now, that's incredible, that alone. Right? But did you want to talk about the permanent principal reductions as well, Michelle?
That's just amazing. Amazing. In September, 72% of eligible non-agency mortgages benefited from principal reductions through HAMP.
So when we say non-agency, we mean that, of course, you cannot get a principal reduction, only a principal deferral, but you can't get a principal reduction if you have a Fannie or Freddie, VA, FHA loan. So it's very important that you check Fannie Mae loan lookup, Freddie Mac loan lookup to see if your loan is in fact backed by Fannie or Freddie, because then you know you can only get a principal deferral. But what Michelle is saying is that of those loans that were not part of a GSE loan, then 72% of those borrowers received a principal reduction. That's huge.
That's huge.
Can you imagine? Why wouldn't you be in that 72% pool? If you were able to qualify for a HAMP loan modification, there is a more than 50% chance, it's 72%, that you would be able to receive a principal reduction as part of that loan modification. And that could result in hundreds of thousands of dollars forgiven from your principal balance on your mortgage. If you haven't done this yet, what are you waiting for? I'm going to give you some numbers that I want you to jot down. The toll-free number for the law firm of Morris DuPont, so you can schedule your free consultation. I will go ahead. I will do all the work to see if your loan is a Fannie Freddie. I will do the calculations whether or not I think you can qualify for loan modification. It's a free consultation. You need to call this number. It's 800-974-2712. That's 800-974-2712. Remember, we have offices in St. Petersburg, Tampa, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, Boca Raton, and West Palm Beach. We are happy to meet with you and see whether or not you can qualify. This program is not going to last forever. Make it your New Year's resolution. You're going to be working on this before the new year to see whether or not you could possibly qualify for these kinds of reductions that we are seeing. Over 1.2 million homeowners receiving permanent modifications just through HAMP. That's not including the in-house loan modification programs that every lender has available. And how much have they received in principal reductions? $12.1 billion in principal reductions. Why haven't you tried to do this on your mortgage yet? I don't know, but now is the time to call, or remember the website. It's homemortgagelaw.com. homemortgagelaw.com will direct you to the Morris DuPont website so that you can get the contact information through the internet. You can request someone to call you to schedule your free appointment for you, and you can speak with me, one of us at the law firm, to see whether or not we believe you can qualify. And if you can't, let's talk about alternatives. We're going to be talking about short sale. What does it mean? How can you qualify for that? What about the deficiency amount? What's going to happen to that? Are you going to be personally liable? Of course not. That's the goal of every client that we have with a short sale. They want to be released of personal liability on the deficiency amount. That's the goal of every client. We want to win. We want to get you that deficiency waived. Let's talk about investment properties. Let's talk about relatives' properties. Let's talk about that empty lot that you own over in Cape Coral, that it doesn't matter what price you put it at, no one's willing to buy it. Maybe your lender would agree to a deed in lieu. You won't know until you make the call. I'm going to give it to you one more time, 800-974-2712. And when we come back from break, we're going to talk with Michelle more about some of these debt settlements she's doing and how that process works.
Again, that toll-free number for the law firm of Morris DuPont, PA, 800-974-2712, 1-800-974-2712. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by Morris DuPont, PA. We have attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. So if you're in your car, if you're at home, maybe you, your neighbor, anybody needs some help. That's why they're here, the experts. And call the toll-free number. You can talk to them right here on the air. It's 866-610-NEWS. That's 866-610-6397. 866-610-NEWS. AT&T Wireless Customer Star 610.
And I'm Shay DuPont here with bankruptcy attorney Michelle Hanash. And we were talking at the beginning of the show about sort of the basics, what the process is for a foreclosure if you default on your mortgage. But we were also talking about what happens with Michelle's clients because, of course, Michelle being a bankruptcy attorney, she also deals with debt settlement and credit restoration. So on that debt settlement, a lot of the clients you see, Michelle, are actually people that have been sued by their creditor, right?
Right. And in fact, even if you have been sued by your creditor on credit card debt, loans, medical debt, you can still settle. If bankruptcy isn't the right option for you, just because you have been sued doesn't mean all is lost and you should just give up. We absolutely can still engage in debt settlement and successfully do in our clients' cases. When we last were speaking, we were talking about what the process is if you are getting sued by your lender on a credit card matter. And when we left off, we were talking about actually getting served with the complaint, which will have the same rules apply as we were talking about regarding being served with a foreclosure complaint. Proper service has to be made, as Shay discussed. Additionally to that, you should look at the complaint to see what's attached to the complaint because the lender is required to have attached something proving this debt. If it's the contract, if it's a statement, there are arguments to be made as to what is proper to be attached there. But you want to look to see whatever is attached to the complaint. You want to see if it's your correct account number, if it's the correct name, the correct lender. We actually do have a client who reviewed his complaint, and it was a completely wrong account number. He has no idea what it is. So we are actually, not surprisingly, fighting this.
And statistically, they have shown that with these credit card complaints, very often the creditor has wrong information attached, wrong accounts, wrong amounts due, wrong balances, wrong contracts. If the contract is included, it's not even the contract for that particular client. So my argument would be, why bother trying to figure it out on your own? Contact the law firm of Morris DuPont and let us review it for you to make sure that the proper procedures have been followed by your lender, not only for the process of service, but also for the contents of the complaint and the attachments there too.
Certainly don't just assume that everything is proper and not respond, which takes us to the next point, which is what do you do when you're served with the lawsuit? So obviously, as Shay's saying, you want to seek legal advice. This is a legal matter. Even if it's a $3,000 credit card lawsuit, you're engaged in litigation and you shouldn't go through this alone. And the last thing you want to do is not respond to the complaint. That's the absolute worst thing you can do because immediately you'll have a default judgment against you when that time period expires for you to file some type of a response to the complaint. And maybe I actually spoke too soon. The worst thing you can do is probably respond by yourself to the complaint wherein you admit everything in the complaint unwittingly.
Yeah.
It's probably better to get a default judgment entered against you because then an attorney can try and remedy that. But you don't want to go through that alone. You don't want to file some type of a response to the complaint that you don't understand is actually causing you more harm than good. I've seen clients come in who wrote a letter as a response to the complaint giving their hardship. And while it's compelling, the judge cannot take that into account to dismiss a lawsuit against you. That's not how it works. You need the proper legal defenses to be alleged on your behalf in your lawsuit. So the important thing is to really seek legal advice regarding the complaint once you're served.
So let's talk about what happens once you're served regarding settlement, because we know that if you settle outside of litigation, let's say that you defaulted on a credit card debt, it's been a year, you now have some money available, maybe a small amount of money, but you would like to try and see if there is a way to settle that. What are the typical percentages that you see with your clients regarding what they're able to settle for before litigation is initiated versus what they're able to settle for once litigation has begun?
Outside of litigation, the average settlement is typically 35 cents on the dollar. So you are paying 35 cents on the dollar to settle this debt, with the balance being forgiven by the lender. Typically, you want to have the funds available in a lump sum payment. That's how you're going to get the best settlement. And if we are able to negotiate a settlement under 35%, it's always going to be in a lump sum fashion.
Okay, so just as a very simple example, it's a $10,000 credit card debt, and you're suggesting that you could settle that credit card debt for $3,500, which is 35 cents.
Exactly. And
35%.
And it's not unreasonable to expect to be able to perhaps pay that 35% over 3 monthly payments. That's a typical time frame that a lender is willing to work out. Of course, we've been able to extend that even at lower percentages, but 35% in 3 monthly payments is not atypical, although it's best to be able, if you can, to have those funds in a lump sum to get the best settlement possible. Now, we compare that to settlements once litigation has already commenced. In that case, we're looking at a settlement closer to 50%.
Ouch.
Yeah, it does increase. Now, once again, it doesn't mean we're not able or haven't settled at 35% even over a year once litigation has started. And it really depends on your specific circumstances, what that balance is. If you have a very high balance, maybe we're going to be able to settle it for under 50%. If you have a $100,000 loan that we're settling, maybe we'll be able to settle that for $20,000 lump sum. So these are just general principles that we're talking about, 50%. And in fact, last week, I actually had 2 settlements, nearly identical balances, one inside litigation and one outside of litigation. The first account was in the amount of $24,914, and that was a lawsuit that we ended up settling at 50% around for about $12,000. The second account that was settled outside of litigation last week was also $24,212, so slightly less. And we ended up settling that account for $8,475, which is actually about 33%, if my math is correct, in 3 payments. So just that difference, I mean, it was almost comical in a sense. We have 2 exact balances,
Right.
just the difference that we were able to do inside the litigation versus outside.
But who's got $12,000? If they
There
had
are-
$12,000, they wouldn't have credit card outstanding balances like that.
There are people who, for whatever reason, bankruptcy isn't the right option. And maybe in very limited circumstances, it does make sense to touch something I normally say never touch, which is a retirement account. Or maybe family is willing to help to get you out of this. And maybe you're going to start paying your dad back at no interest because he's your dad. And then you can get out of this. You know, that's what we see typically.
Right. And that is, again, of course, the bankruptcy department dealing with this, because you understand whether or not it makes more sense for someone to file bankruptcy and to be released of this debt versus settling it. And some of these specific smaller amounts, maybe they have other assets that they don't want to have to include in a bankruptcy. So settling this credit card debt makes more sense for whatever reason.
Well, we had a caller last week who called about bankruptcy who had a $200,000 investment property,
Right.
and that's all he has, and that's really a family investment. He doesn't feel that's something he can sell, or it's just for his benefit. And if he did file a bankruptcy, that property would be considered an asset. So that's a
Right.
good example.
Well, if you have questions about credit card debt, if you have questions about whether or not you can qualify for bankruptcy, if you are looking at different alternatives for your mortgage, which include maybe settling a second mortgage or looking for a loan modification, call the law offices of Morris DuPont. You can reach us at 800-974-2712. That's 800-974-2712. 2712. There are people in the office right now who can take your call.
And we've got Joaquin and Randy that we'll get to right after the break here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. If you can hear the show, there is an office near you. We'll give you the number throughout the show. It's a toll-free number. In the meantime, if you want to talk to the experts right here, right now, you can do so. Just pick up your phone and dial toll-free 866-610-NEWS. That's 866-610-6397. AT&T Wireless customer star 610. We have attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney, here with you until 4.
You know, Natalie, we're going to go to the phones, but I must say you're looking especially beautiful today. What is the deal with the completely made-up face and, dare I say, false eyelashes?
Falsies, yes. I'm rocking
Falsies
the
or
falsies.
something else.
I love
Yes,
it.
yeah.
Well,
I said false eyelashes. She said false.
I call them falsies.
Well, maybe. We don't know.
Where are you going this evening, my friend?
I'm going to Arthur Murray Lauderhill. It's a ballroom dance studio. They're having a showcase. I'm a judge. Very proud to say I'm a judge.
A judge, but you're a dancer as well.
Yes, I am a dancer as well.
Oh, bravo. So where is that going to be?
Arthur Murray Lauderhill off at University near Commercial.
Bravo, bravo.
So come cheer us on.
Absolutely. Would
All
love it. Let's get to the phones. Let's talk to Joaquin.
Hi, Joaquin.
Hi, Joaquin. What can we do for you today?
Yeah, hi. I'm renting a home, and I got served foreclosure papers last Thursday, and I want to know where I stand.
Okay, so there are some laws in the state of Florida that protect a tenant in the case of the landlord owner being, served with foreclosure. So what the law says is that should the property be sold at a foreclosure auction, whoever buys it has to let you stay there for a minimum of 90 days. And if it is bought back in by the investor, right, by the lender, or if it is bought by someone who plans on using the property as an investment property, not their primary residence,
That's my work, though, man. Call me anytime, and we'll talk. Yes.
then I'm hearing a bit of background. Then they must allow you to stay there through the entire length of your lease. So if you had just signed a lease on November 1st and you got served on November 2nd, and the property is sold at a foreclosure auction in May of 2014, if it's bought back in by the lender or bought by an investor, they would have to allow you to stay in there until the lease expired October 31st. But if it was bought by someone who's going to use it as their primary residence, then they have to only allow you to stay there for 90 days. And remember, if a foreclosure action is properly defended, such as by a law firm like Morris DuPont, we typically tell our clients that from the date they are served with the foreclosure action, we can keep them in that property for a minimum of 18 months. But I'm going to give you a little tip so that you can monitor your landlord's case. Do you have a computer?
I'm on the phone and in my car.
Okay, so do you have a computer that you normally have access to that you can look up things?
Absolutely.
Okay, great. So what county are you living in?
Palmetto Bay, Dade County.
Dade County. So you're going to use these keywords, Miami-Dade County Clerk of Court. And the first website that should show up is the actual Miami-Dade Clerk of Court website. You click through that website. You click through online services. You click through civil cases, because this is a civil lawsuit that your landlord is now involved in. Don't ignore all the foreclosure stuff on the Clerk of Court website. That's about buying foreclosure properties. That's not what you want to do. You've got a civil case, so you want to look online services, civil case, and then it will show a place to put in the name. Put in the name of your landlord, and voila, it should show you a list of cases that your landlord has ever been involved in. Maybe this is the only one. Click through that, and you can see what's called the docket for the case, to see how the case is progressing and how much activity there is on the case. Once there is a sale date set, that will show up on the docket. And again, I wouldn't expect anything to happen with any seriousness to this case in the first 6 months. A lot of it is just discovery and motions going back and forth, so you've got plenty of time. Of course,
Okay.
one of the things I would do, Joaquin, is I would contact my landlord and say, hey, I thought I was going to be able to live here for a certain amount of time. I didn't realize it was in foreclosure. Now it's in foreclosure. There's a certain amount of uncertainty. I would like to receive a discount on the amount that I am paying. So if you were paying $1,200, maybe I'd say, look, I want a discount. I want to only be paying $900 a month now. You certainly have to still, pay to live there, but I would certainly be requesting some sort of a discount.
Okay. Sounds good.
Does that make sense?
It does make sense.
All right. Well, I think you've got plenty of time, but communication with the landlord and keep an eye on the docket.
Okay. Thank you very much.
All right. Wish you the best.
Bye-bye.
All right. Let's go to Randy.
Hi, Randy.
Hello.
Hi. How can we help you today?
I'm trying to get a mortgage. I'm an independent contractor, first-time home buyer,
Mm-hmm.
and I was trying to get between $100,000 and $140,000 home. I have $60,000 to put down, so I'm looking to get about a $60,000 to $80,000 mortgage.
Right.
When I applied at my bank, the initial application, they said I was approved for $275,000 loan, which is a lot more than I wanted to have.
Yikes.
But that was until I took in my tax return, being an independent contractor, and the deductions and the loss that I took doesn't show enough monthly income to qualify for the loan. I want to know what my options are as far as how can I get, say, a 50% mortgage being an independent contractor and without too drastically changing my tax return.
Right, exactly. I understand what you're saying. You've got to show evidence of that income, but it's sort of a catch-22. I'm sort of surprised that the first time that you went in and spoke to someone, they said that they were pre-approving you for $275,000, yet they had not yet seen your tax returns. Typically, a mortgage broker will not even talk to you about numbers. They'll ask you how much you want to borrow. They'll ask you how much you're willing to put down, but they're not going to volunteer any information as to how much they believe that you could qualify to borrow unless they see a complete financial picture. And one of the key components of that is, of course, your tax returns. So I'm kind of surprised at this quote of $275 without seeing your tax returns. So
I was.
I'm sorry, what were you going to say, Randy?
No, I said I was surprised too.
Yeah. So it is more difficult when you are self-employed to be able to show the sufficient income because, of course, for tax purposes, your profit and loss statements are showing gross revenue, and then you're piling in any sort of business expense you possibly can to get to a net revenue that's as small as possible because that's what you're going to be paying taxes on.
Right.
And in your situation, you then, of course, your net revenue is for the business is your personal gross monthly income, and that's what the lender wants to see is a higher gross monthly income to be able to show that you can actually afford these mortgage payments. So what I would probably be wanting to do is to be showing those profit and loss statements for the business and extracting some of those business expenses, transferring them over to the personal side so that your net revenue is larger, and i.e. your gross monthly income, your net revenue for the business is larger, i.e. the gross monthly income for your personal is higher, and see if you can then work with a lender who understands this. And that might require not going to one individual lender, but to actually use a mortgage broker who is going to show you how best to show your income so that you can better qualify with different lenders that mortgage broker has available and can access for you so that they can help you to market and get a loan at the best possible interest rate. So I would suggest working with a mortgage broker and using the profit and loss statements that aren't going to be submitted to the IRS. I use profit and loss statements all the time with my clients, requesting them when they are self-employed, when they are wanting to try to qualify for a loan modification, A lot of times people think, oh, I can't qualify for a loan modification because I'm self-employed. That is not true. Of course, you need to be able to show the lender your profit and loss statements. And it's very easy to do that. I mean, it can be done handwritten. It's not that the lender requires them to be done by an accountant. So it sounds like you have a good grip on the accounting part of the business. You just want to understand how you can use your profit and loss statements and your tax returns to show the lender the sufficient income that you have to be able to qualify. So are you on Facebook, Randy?
No, I got off Facebook, actually.
Oh, too bad, because Home Mortgage Law Show does have its own Facebook page, and I'm going to put that information up there for a couple of mortgage brokers, Pam Marin and Alex Morales. You can call me at the office, and I'll give you their names.
Super.
All right.
Let me ask, what you're saying
I got to
is,
take a break. I got to take a hard break at the top of the hour, but if you want to hold on, we'll come back and talk to you.
You're listening to the Home Mortgage Law Show, 1-800-974-2712. That's the toll-free number to call and for your free consultation at the law firm of Morris DuPont, 800-974-2712. If you can hear the show, there's an office near you, 1-800-974-2712. We'll have more of the Home Mortgage Law Show right after this.